The Supreme Court has upheld the constitutional validity of SEBI's rules on fund closure, making it clear that SEBI has the power to intervene in closure of debt schemes. Prima facie, the court agreed with the view taken by the Karnataka High Court, stating that the nod of investors is needed to close any sort of debt funds. Franklin Templeton had moved the Supreme Court against the Karnataka High Court order, which had stopped winding up of 6 debt schemes of Franklin Templeton without the nod of majority of investors. In a judgment pronounced by Justice Sanjiv Khanna, the court made it clear that SEBI's rules will apply and the consent of unit holders will be needed for winding up of any debt schemes. The court upheld this view of the High Court. However, it made it clear that consent will have to be obtained only post publication of notices. While the court also upheld the legal validity of mutual fund regulations, it also made it clear that SEBI can intervene in case of violations and wrong decisions by trustees taken in case of winding up of debt schemes. The court had held that the judgment was withheld till now to prevent any prejudice in the proceedings which were going on before SEBI. The court's judgment has clarified that it has not gone into the facts of the case, rather has only examined the law's theoretical interpretation, taking note of news reports that SEBI had passed an order in its proceedings which are currently pending challenge before the Securities Appellate Tribunal. The Apex Court has made it clear that parties in this case are free to move SAT and seek an early hearing in this case, since the hearing for now has been fixed for the 20th of October. The court had earlier allowed distribution of the proceeds worth over rupees 9,122 crores to the unit holders of the 6 wound up Franklin Templeton schemes. Franklin Templeton had decided to wind up 6 debt fund schemes last year, and the move was stayed by the Karnataka High Court on the ground that debt fund schemes cannot be wound up without an approval from a majority of investors. After Franklin Templeton contested the High Court order and the voting by unit holders was conducted, the top court refused to stay the voting results or the dispersal of funds. Many unit holders who had moved court had complained that SEBI did not perform its statutory duty during the winding up, while SEBI countered the allegation, submitting that a preliminary inquiry was conducted and a forensic audit report was submitted before the Apex Court in a sealed cover. However, SEBI maintained that there was no precedent of sharing forensic audit reports, claiming that making them public will open up a Pandora's box with multiple cases seeking further details. Referring to a ruling by the Central Information Commission, SEBI had contended that it was not under any obligation to make the forensic audit report public. It remains to be seen whether any fresh petitions will be filed before the SAT in this regard after the Apex Court has already delivered its judgment in the case.